if you're intentionally impeding and interfering with government operations.
I'm not intentionally doing anything. I'm standing on a public sidewalk.
I'm just letting you know right now, if you continue to intentionally interfere with the van's operations, that's interference and obstruction of the government operation.
What's going to happen then if I continue to stand here?
You'll be cited with obstruction if you continue to interfere with his operation.
There's no law that says that I can't stand on a public sidewalk, sir.
All right, then why don't you film him from a different spot?
I'm a free American, sir. I'll film from wherever I want to film.
You've been warned. Do we need to go beyond that?
Well, I'm going to exercise my First Amendment right, and I'm going to stand wherever I want to stand on a public sidewalk.
As long as you don't interfere with his operations,
then you guys need to move then. If I'm interfering, you guys need to move your operation somewhere else.
Okay, then you're free to go.
I'm free to go?
You're free to go.
Okay. Free to go, free to stay.
Is there anything else I can do for you today?
I mean, you haven't done anything for me. I never needed you.
Welcome back. As many of you guys know, I'm a law enforcement trainer instructor. I train and instruct military and law enforcement all over the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, use of force, investigations, etc. And here we have a really horrible attempt, this officer's horrible attempt at not only communication, but again, it seems like there is a theme around here trying to talk a nexus of crime onto a citizen. Trying to somehow, if I say it enough times, then all of a sudden it'll, either you're going to understand what I'm saying or it'll just make sense. So again, it seems to be the theme the last couple days. I don't understand what these officers are doing. I think I might see what they're attempting to do, but it's absolutely ridiculous. So let's just look at the law. Let's look at the law here. So this is out of Colorado. So I believe this officer is probably, as you can see on your screen, probably trying to quote Colorado Revised Statute, Title 18, TAC 8, TAC 102, obstructing government operations. And as you can see here, a person commits obstruction of government operations if he intentionally obstructs, impairs, or hinders the performance of a governmental function by a public servant by using or threatening to use violence, force, or physical interference or obstacle. And so that's what it is. Now, in and of itself, it does seem a little vague, but when you actually pull up the elements, so when you actually look at, for example, the jury instructions on this, it seems to be evidently clear. So here we have, here on your screen, elements of a crime. Under Colorado law, the crime of obstruction of justice is defined by specific elements that must be proven beyond a reasonable doubt for a conviction to occur. The prosecution is tasked with demonstrating that the defendant's actions were deliberate and intended to impede the execution of legal duties. Critical to this process is the concept of criminal intent, which necessitates a thorough evidence evaluation to establish the requisite state of mind, also known as mens rea. So, to secure conviction for obstruction of justice, the following elements must be established. Number one, an intentional act, right? The defendant must have knowingly engaged in an act that obstructed, impaired, or hindered the performance of a governmental function or enforcement of the law. This element is pivotal, requiring the prosecution to prove that the act was not accidental. Number two, criminal intent. The prosecution must show that the defendant possessed the intent to disrupt government operations. This involved a careful examination of the evidence to ascertain the defendant's mindset at the time of the alleged obstruction. And three, the impact on governmental operations. The act must have had tangible effects on the functioning of government operation without demonstrating the impact. The charge of obstruction lacks substance, right? And so these elements collectively form the foundation of a charge of obstruction of justice in Colorado. So based upon the facts, based upon this, is evidently clear that this guy isn't even close to obstruction. Like, I don't know how this officer is planning on articulating it. What it seems like this officer is doing is stating, by you videotaping, I just want you to know you're intentionally obstructing. Somehow, if he says it enough times, it's going to somehow magically make it real. And again, these officers they don't know the law. And again, they're trying to formulate a nexus based upon their own beliefs, their own beliefs and opinions. Like, here it's clear the mens rea is not there. Here it's clear the intentional act isn't there. And then on top of that, try to get him to actually explain the impacts on governmental operations, right? And so I think I think what we're seeing here is, again, it's horrible to say, but it really looks like, if you're looking at this from a reasonable person, because that's how the courts are going to look at it, it looks like contempt of cop. That's really what it looks like. And so, based upon the video, it seems like there is a van, maybe an unmarked van. It could be a van that's doing any listed things, right? It could be doing a wiretap. It could be doing radar and then relaying that information. It could be doing undercover work of any sort, right? I mean, there's lots of different vans. There's lots of different vehicles that are used in law enforcement. I mean, the ones I've worked with, many, right? Everything from mobile forensic units, vehicles that can forensically dump electronics, to ones that are doing wiretapping or running radar and notifying other units of speed, right? So there could be a whole litany of different things that an undercover van might be doing. But we have to go to what is the person doing, and it's very clear the person states, I am engaged lawfully in a constitutionally protected activity. Again, as you can see, let's read the First Amendment. Again, let's read it again. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peacefully assemble and to petition government for redress of grievances. So again, I think the person's being 100% clear. He's like, I'm here to engage in a constitutionally protected activity pursuant to, in accordance with, the First Amendment. You can't weaponize that and make that a crime just because there is a law enforcement function going on. Just because there is a vehicle that is doing some kind of law enforcement function, the fact that this person is intentionally, willfully engaging in a constitutionally protected activity doesn't mean that you can say, oh, governmental obstruction. Let's just hit you with governmental obstruction. It's nonsensical. But I get it. There's a lot of cops out there that don't believe in the Constitution. They think it's an old, outdated manuscript. So again, let's go into it further. Let's talk about the right for the detainment and the right for trying to compel ID, right? Because this person, it does appear he feels like he's being detained. It looks like he's being detained. So Supreme Court has affirmed that law enforcement needs reasonable articulable suspicion in order to detain and compel somebody to identify themselves. Brown v. Texas, 1979. Here, I do not believe the officer has reasonable suspicion of a crime being occurred, right? And again, it's the soft, subtle language of, if you keep intentionally doing this. So in his mind, the officer, I really truly believe the only thing that makes sense is officers, if he says it enough times, if he says you are obstructing enough times, if he says if you keep intentionally impeding, maybe that's what he needs to feel better about making the arrest. I don't know, but that certainly seems to be the route that he's taking. Here we have the burning of the American flag, right? The burning of the American flag case law, flag burning case law, Texas v. Johnson, 1989. Again, the Supreme Court has held that flag burning constitutes symbolic speech that is protected by the First Amendment. Furthermore, the Supreme Court held that the freedom of speech protects its actions that society may find very offensive, but society's outrage alone is not justification for the suppression of speech. So it's clear that this officer finds this journalist, this law-abiding citizen, peacefully engaging in the lawfully protected activity of the First Amendment of freedom to record, freedom of speech. Just because he finds that outrageous does not give him the permission to suppress it. And so again, when we look at this from all matrices here, I don't know what this officer's going to do. And for you officers out there, right? Like, if you're going to go down this road, again, like I've said in other videos in the past, I am not here to tell you how to do your job. But if you're going to go down this road of obstruction, just know there are jury elements. There are elements for obstruction. There are elements for what needs to be proven. And so this idea that you're just going to be able to play your body camera, and just because you said on your body camera, or if you don't stop intentionally impeding, that doesn't mean anything, right? That doesn't mean that the prerequisites have automatically occurred because you've said it. You have to articulate, well, how was he obstructing justice, right? How is he obstructing government operations? Did they have an inability to continue on? You're going to have to explain. If you want to make that nexus, right, you have to explain those three elements, right? How did he physically impede? What did he do? How could the government not continue on in their operation because of his actions of filming? You're going to have to explain that. And if you do go ahead and make that arrest, again, that's an easy lawsuit. Again, 42 U.S.C. 1983, you are making it way too easy. And so, again, I'm not going to tell you how to do your job, but again, if, like I said in my last video, if you are a law-abiding citizen and you're watching this and you don't understand it and this is foreign to you, I'm telling you, as a nationally certified law enforcement instructor, I don't get it either. That's two of us. It makes two of us. I don't get it. I don't know how you articulate it, right? I don't know. I don't know how you are going to surmise and make that nexus on the stand and go up against an attorney that knows what they're talking about. Like, I don't know how you're planning on doing that. I don't. And so, man, you know, it is what it is. I hope, you know, we don't have the full video, but I hope that this officer came to his senses relatively quick and realized that he was in over his head and chose not to make that arrest. But, hey, that's neither here nor there. The bigger question and the bigger thing that matters here in this case is, what do you guys think? As law-abiding citizens, as people that have, that are watching this, that have the case law in front of you, what do you think this officer's doing? What do you think he's attempting to doing? Why do you think he's attempting to do what he's doing? And what do you think? I'm interested to know in the comment section below. If you guys like this content, please like, share, subscribe. And as always, guys, long live the Republic.